Pretty much every consumer contract we sign, whether it be for our cell phone, a credit card, our internet service provider, has buried deep within it what's called a forced arbitration clause. Now that might be a new term to you, but what that means is if you have a problem with your vendor, like your phone doesn't work, you lose a lot of money because of a data breach related to your credit card company, you can't sue them. You forfeit your constitutional right to a jury trial in favor of what's called forced arbitration. Now, forced arbitration is a secret black box tribunal where the company picks the decision maker and they tell you what you're going to get. Now, the data show that about 97+% of the time, you're going to lose. And you're going to lose because if the arbitrator rules for you, the company's not going to hire him again. And it's a for-hire undertaking. It's a terrible, gross, underhanded, skeevy, slimy process. And that law derives from a U.S. Supreme Court case, Concepcion versus AT&T, where Justice Scalia, for the majority, wrote that these sorts of arbitration clauses are legal. Now, granted, the arbitration laws were enacted back in the day as it concerns business-to-business disputes, where each side was informed, had a lawyer, had knowledge of what was in the contract. You cannot say that holds up as it concerns consumer contracts. I just told you these things were in your contract and you probably didn't know. So that proves that theory. But you know what? Doesn't matter. The Supreme Court said that's the law of the land. Now it is. So companies across the board have them. But it gets worse. You might think, hey, listen, if it's an arbitration, I'm probably going to lose. Maybe a class action arbitration. Lots of people will gang up and will have like 10,000, 100,000 victims of this fraud, this sham suing the company. Well, you know what? The companies are ahead of that curve too. They have what are called class action bans baked into these forced arbitration clauses in these consumer contracts, which say, hey, listen, when you arbitrate, you've got to arbitrate your individual claim, period, end of sentence. And that means no lawyer can help you because it's not worth any lawyer's time to take a contingency fee or any fee based on maybe a $50 recovery. They can't stay in business. You're going to go it alone. You're probably going to lose as you were going to lose anyway. So these forced arbitration clauses are everywhere. You can't write them out. You can't go from one cell phone provider to another hoping not to find one. They're in all of their contracts. You just need to know what's in there so that if something happens to you, at least it's not a surprise. At least you know going in what your rights are, and you can take whatever steps, hopefully, to avoid the possibility of a lawsuit, because you're probably going to lose the arbitration, not the lawsuit. So anyway, that's a little primer on what's in all of these contracts, what's lurking beneath the surface, the sinister arbitration and class action ban language that we're all stuck with. But now you know, and now you can hopefully take some steps to avoid a problem that involves arbitration, because it's probably not going to go well for you.